Good afternoon. Attorney General Martha Coakley. On my right is Assistant Attorney General Jim Sweeney, and on my left is Assistant Attorney General Jason Barshek. They are two of many of the members of the Attorney General's office, lawyers, paralegals, and other assistants with Special Attorney Paul Ware, who've been involved from the beginning of the civil and criminal charges arising out of the tunnel ceiling collapse. Today, the Commonwealth announces that we are closing most of the civil and criminal matters that did arise out of that ceiling tunnel collapse back in June of 2006, the collapse that killed Melina Del Valle as she was on her way to the airport. And as a result of the agreement reached today with Powers Fasteners, the Commonwealth has entered into a Deferred Prosecution Agreement that includes a corporate compliance agreement that I will discuss in a minute. And in terms of the settlement of the civil suit, Powers has agreed to pay $16 million, 15.5 of which will go to the Commonwealth and the remainder to the city of Boston as a result of damages that we allege, and they agree by the settlement, were incurred as a result of that tunnel collapse. As you all know, that tunnel section was in the I-90 connector and fell and collapsed the car in which Melina Del Valle and her husband were traveling. What we believe is important about this resolution are several things. I remind everybody that in Massachusetts, the penalty for a corporate conviction for manslaughter is a mere $1,000 fine. We believe that given the goals for the Commonwealth and indeed for the family in this instance, what we have been able to achieve today is a far greater result and more consistent with the family's wishes as well as in the best interest of the Commonwealth. By terms of this agreement, Powers will immediately stop the sales and production of the Powers Fast set, the epoxy that was used in the Interstate 90 connector tunnel to hold the panels up. Powers must terminate all sales and production of other adhesive anchors unless an accredited lab issues a report that the product complies with applicable technical standards and Powers uses commercially reasonable steps to obtain final approval from the appropriate regulatory agency. Equally importantly, Powers must recall all of the fast set product that's currently in the field, and Powers will issue a notice to end users within 60 days and also make sure that we provide for the notice to every place that Powers believed that this particular product was used. Again, I can stress the importance of that because we have been and were concerned about the appropriate application of this product. And by this corporate compliance agreement, which will be monitored at Powers' expense to make sure there is compliance, and a built-in penalty should they fail to do it of $100,000 a year, we believe accomplishes at least the goals of deterrence for Powers, for other companies like it, as well as providing for the safety of other users of this particular product, not only in the United States but globally. As a result of the civil settlement, and in the year 2006, in November, the Attorney General's office filed a comprehensive civil suit for negligence and breach of contract damage against many parties, including Powers. Today's resolution and the payment of $16 million resolves that civil claim as well as many of the other claims that were outstanding with the Attorney General's office. That money, the $15.5 million that will go to the Commonwealth, goes to the Transportation Infrastructure Fund that is maintained by the Commonwealth for expenses related to highways and other infrastructures in the Commonwealth. We have consulted with and notified the family. They, as you are aware, will be available, or their counsel will be available later for comment. We had conversations earlier and during this with both Melina Del Valle's daughter, Raquel Ibarra, and her husband, Angel Del Valle. They have approved of this. In fact, at some stages, they had encouraged us to reach this settlement. As you may know, they and their counsel had reached settlement not only with Powers earlier, but also with Bechtel, Parsons, Brinkerhoff individually, and as they were a joint venture. What I can say is that unusual situation. that we faced coming into this office 2 years ago, and the team that we placed on the multitude of issues that we had to face. As you recall, there was an extensive criminal and civil investigation in conjunction with the U.S. Attorney's Office, for which we are grateful for their help and assistance, with the FBI, with the National Transportation Safety Board, and with the Transportation Department of the Federal Inspector General's Office. We did reach a settlement earlier with the U.S. Attorney's Office and Bechtel Parsons Brinkerhoff, as they were a joint venture. We believe today that in the interest of all of the parties and agencies, including the families, that these damages and restitution, the deterrent effect on Powers as well as on other companies, the public safety issues, particularly the ability to try and notify and recall the product and its use wherever it may be, although not perfect, we think is the best result after all of this time and in lieu of a lengthy and expensive trial, which, as I indicated, at best would recoup for the Commonwealth a $1,000 fine. I recall that when I did meet with Raquel Ibarra and Angel Del Valle sometime during this investigation, their plea to me then was that they did not want this to happen to anybody else. And we have kept that goal in mind in looking at our negotiations with Bechtel Parsons and the joint venture. We have kept that in mind both as we sought criminal charges against Powers and now as we have resolved it. We think the most effective way to resolve that goal and to resolve the concern of the family for public safety.